Good afternoon. Before we begin, I would like to acknowledge the traditional owners and custodians of the land on which we are all gathered today and to pay our respects to their elders past and present. I would also extend our respect to all other First Nations people who may be within our audience today. Today, we're going to talk about Are You OK Day and supporting workplace wellbeing for all. I'd like to introduce myself and my colleague. So I'm Hilary Searing. I'm a partner at Clayton here in the Workplace Employment and Safety team. And with me, I have Hillman, who is a special counsel in our team. We are going to spend the next hour talking about workplace wellbeing and Are You OK Day. And we're also going to leave some time for questions and answers at the end. But please feel free to put those in the chat function and we'll address those as we go, and also leave some time for those at the end. So what will we be discussing today? Thursday, the 14th of September is Are You OK Day? And it's a day that is designed to help people realise it's okay to ask that question. It's okay to ask that question in the workplace, but how do we then deal with the answers? How do we make sure that we are discussing the ways in which we can support workplace wellbeing for all? Managing and supporting ill and injured employees is an area we are increasingly being asked to help our clients with. And what we're going to talk about today is why, and unpack, is why is this area so hard to manage? Why is this creating so many challenges? And how do we identify the mental health risks and challenges in our workplace? And we're going to talk about some tips as well to how to make this process less challenging. We're also going to talk on recent case law and some developments in this area, and also some intersect with some new case law and new legislation in terms of the positive duties that have come in to manage sexual harassment, and give an update on psychosocial hazards legislation. And how does this all intersect and play a role in a healthy workplace? So as I'm sure you could all appreciate, mental health is an issue for all of us. Even if you have good mental health, there's a strong likelihood that at any time you're working with someone who may have mental illness or poor mental health, or is supporting a family member or friend with mental health issues. Sadly, around 1 in 10 or 9% of Australians have reported that they've been diagnosed with a mental health condition. But it's important to realise that mental illness and mental health are not the same thing. We can have a mental illness and have good mental health, and vice versa. And so mental well-being in the workplace is not just about preventing mental illness, but also about how do we support good mental health. We're here in 2023. It's a new year, new challenges, but we're still seeing some of the old challenges coming into place. So staffing, recruitment challenges, resourcing, how we actually can continue to operate. This is a major challenge for a number of employers. It's placing increasing pressure on employees and managers and organisations and how to manage their roles and their organisations in this challenging time. We've got this continuous push for productivity and the pressure to keep that up amidst the current economic impacts. We have challenging conduct and expectations of our staff, and how do we actually manage those? We are increasingly seeing managers so nervous about doing the wrong thing, or wanting to do the wrong thing, that they're not actually necessarily managing staff. So at a time when that is critical, and we're needing our managers more than ever to step up and to actually manage. And we appreciate that can be incredibly difficult when we're talking about how to manage mentally ill and injured workers. So the challenging face of that is we have the increasing issue of trying to get staff to come into the workplace. We've had COVID-19, and it's had an incredible impact on the workplace. And we really see the changing face of that. We want a lot of employees and organisations are appreciating flexibility and working from home, but then how do we manage that intersect of how do we then get staff to come into the workplace, the physical workplace, and make sure that our culture and our organisation is working well and managing the risks that we're going to be talking about today. We, coupled with all of this, we have changes to the law. We have the Fair Work Act amendments and industrial relations changes. We've got the sexual harassment changes. We've got psychosocial hazards impacts as well as other things. And staying on top of all of that, the law can create its own pressures in the workplace environment. So we're going to talk about some of those legal developments, and I'm just going to, against that backdrop of 2023 and where we're at now, we're going to briefly discuss at the start, and then I'm going to hand over to Laura to discuss how this all fits into modern workplaces. But we're going to discuss the intersect of this new positive duty to manage sexual harassment, and how that intersects with some of the amendments on the psychosocial hazards and changes to those aspects from a health and safety perspective. And I'd like to start with the sexual harassment changes. It's well known that sexual harassment can cause significant harm to those who experience it, to those who witness it, as well as the broader organisation in which it occurs. Both from a cultural, a governance and a safety perspective. Despite this, up until now, sexual harassment claims have typically been dealt with as an individual grievance rather than potentially a systematic organisational issue. But we've now had a new positive duty introduced. This is a change that's come from the Sex Discrimination and Fair Work Respect at Work Amendments 2021. And it was one of the steps that was recommended by the Respect at Work report by Sex Discrimination Commissioner Kate Jenkins, that was not introduced at the time in the previous response to the inquiry. The new duty now requires employers to take reasonable and proportionate steps to eliminate as far as possible discriminatory conduct. And this is, in our view, going to require employers to significantly step up their current sexual harassment risk management practices. So there's got to be a real shift or a change in focus from fixing the problem after it occurs and typically responding to complaints to taking proactive and preventative action to eliminate the unlawful conduct. It's similar to the obligations in the work health and safety space, that it's going to require employers to have an end-to-end framework that identifies your sexual harassment risks, that, and then making sure you've got those appropriate controls in place to eliminate, or if that's not possible, minimise those risk factors, and making sure that those controls are actually working. The Australian Human Rights Commissioner will monitor compliance with this new positive duty, and they've been provided with a range of regulatory tools to enable them to do that. They can conduct inquiries into compliance, they can issue compliance notices, they can apply to the federal courts for an order to direct compliance, and they can enter into enforceable undertakings. But those powers are not in effect yet. That those powers are going to be coming in on the 12th of December 2023. So where to from here? For employers, we would say it's an opportune time for you to consider your existing sexual harassment response and frameworks. Often your workplace health and safety system could be a good place to start, and you can identify what risk factors exist in your organisation for sexual harassment. Are you aware of any particular risk factors such as power or gender imbalances, frequency of complaints that might be arising in a particular area of your workplace, for example? You could consider what controls are then going to be required to address those particular risks, and then how are you going to manage and ensure those controls are working. Some of the starting points that you might want to think about is supporting a safe speak-up culture, reviewing and updating your policies and procedures, especially your complaints frameworks, and making sure that those are targeted and effective, and people know what conduct is going to be considered unlawful and inappropriate in the workplace, and what steps they can do if they have a concern, and how do they raise complaints. The discussions, discrimination and harassment training is going to be important, including bystander training, And again, that continual monitoring piece to make sure that the frameworks and the steps that you're taking and you're putting in place are actually working to manage the risk factors that you've identified in your workplace. As I've mentioned, talking about the frameworks on the WHS space being a good place to start, it's clear now, if it wasn't before, that sexual harassment has been identified very clearly as a safety issue. It's recognised by work health and safety laws as well as the sexual harassment legislation that it is a workplace hazard, that it creates physical and psychosocial risks to health and safety. It's called out as a particular psychosocial hazard, which are workplace hazards that relate to the psychological and social conditions at the workplace rather than just physical conditions, and they can lead to physical or psychological harm. There's now a positive duty to manage psychosocial hazards in the workplace in a number of states and territories across Australia. I'm going to pull up a slide in a moment which talks about the status of where all of that legislation and regulation is at. But this positive duty, as you will place a similar duty on employers to actively manage the risks of psychosocial hazards, which are distinct from physical hazards, and the importance, again, of encouraging and exploring that reporting and how do we address those compliance. A good example, I wanted to talk about a case I thought would be a really good example of the intersect of the sexual harassment and the psychosocial hazards case that actually only just came down this month in August 2023. It's a Fair Work Commission case of Lindsay Swift and Highland Pines. And in that particular matter, it's a termination for harassment was upheld, but Fair Work Commissioner Sarah McKinnon found that the organisation could have done more and should have done more to encourage reporting. And she, in that case, highlighted the employer's positive duty under both the Commonwealth Sex Discrimination Act and the New South Wales Work Health and Safety legislation to take reasonable and proportionate measures to eliminate, so far as possible, unlawful sexual harassment by their employees. She indicated that Highland Pines, in her view, will need to do more to meet its duty to prevent workplace sexual harassment in the future, including a program of training for managers and employees, and letting go of this notion that an employer can only act on alleged conduct if there's a formal complaint in place, which was a scenario that rose in this case. In this case, in October 2022, the manager of an individual worker received indication from another manager that a number of workers were raising complaints about this particular individual, and found this working with this electrician off-putting because of his propensity to discuss his sex life and ask him about theirs and approach other female employees for dates and yell and swear. The worker was given an opportunity to respond to claims, but ultimately the matter was not dealt with because no formal complaint was actually made. The worker themselves then submitted a medical certificate of incapacity and took leave, contending he had been bullied and harassed and that there had been false allegations made against him. When that was investigated, they were all ultimately found not to be true, but it was found that the worker had engaged in sexual harassment of his colleagues for at least 3 of those, and the conduct had been unwelcome and repeated and occurred on a number of occasions. So Fair Work Commissioner McKinnon found that more could and should have been done, and that this worker's termination was upheld on that basis. So in terms of the types of psychosocial hazards that can exist in the workplace, I've put up here a slide that has come from the codes. Oh, sorry, someone's just asking me for the citation from that Lindsay Swift decision. Sorry, one moment, I'll pull that up. That is it was a 2023 Fair Work Commission case 1997 that came down on the 10th of August. The positive duty and the psychosocial hazards duties are not yet applicable across all jurisdictions, and I'll come up to a slide shortly in a moment which sets out where they're in place and where they're not yet. But in terms of the codes of practice, they've identified 14 psychosocial hazards, of which bullying and harassment and sexual harassment are called out specifically as one of those psychosocial hazards that needs to be managed by organisations. And that's often where we see the ill and injured employees, and particularly in terms of employees suffering stress and anxiety and decompensating and leaving the workplace is generally in this space arising a lot of bullying and harassment and sexual harassment. The legislation and status is set up here. So as you can see from this slide, it's commenced in a number of locations, Commonwealth, Queensland, New South Wales, WA, Tasmania and the Northern Territory. There is draft legislation in place in Victoria, but it's still under feedback, consult. And in South Australia, the regulations just came in on Friday, but they not yet in operation. They're only going to commence 4 months after the date that this legislation was made. But what we would encourage everybody to realise and appreciate is that the information that that is being promulgated in other states and territories, the laws on psychosocial hazards and the codes of practice, which contain some really useful guidance on how to actually identify and manage these risks, will be information. If you're in a state or a territory where you're not yet having to comply with this duty, it will be information that the regulator will probably say that you're on notice of or ought to have reasonably known about how to manage these risks and these hazards, and would therefore encourage everybody to be across this information and to be aware of it and taking it into consideration in your risk assessment and your processes and your management of that. Might come back to some of the questions at the end, but in terms of the managing these risks, as I've said previously, ultimately your existing WHS frameworks are a really good place to start. Psychosocial risks are not something that organisations have been familiar with to date. We're a lot more, used to dealing with physical hazards like a trip hazard or, someone breaking their leg and working out how do we deal with that. But the process is still going to be the same. You still need to identify the risk factors of those 14 particular psychosocial hazards in your organisation. You need to assess what your control measures need to be and assess the nature of those risks. So, the duration, frequency and severity of exposure, for example. Is there more than one psychosocial hazard? Because cumulatively that can create a greater risk, for example. Then you need to make sure that you are putting in place control measures that are going to eliminate those risks so far as reasonably practicable. And if that's not reasonably practicable, you need to make sure that you're minimising those risks so far as reasonably practicable. And every workplace is different. So, it would be encouraging every workplace to have a risk assessment in place that deals with psychosocial hazards and what are they in your organisation, and with a particular focus on sexual harassment and bullying, to make sure that you're meeting those obligations to manage that positive duty in that space. And lastly, and most importantly, I think the biggest issue I see is that people set and forget. We need to constantly make sure that once we've done this process, it's a living document, it's a living process, and that you're reviewing your controls and making sure that they are actually controlling the risks that we have identified and making sure we're putting those in place. So I'm going to hand over to Laura now, and I will come back to some of the questions that everybody's asking about this area at the end, but we're going to talk about how does this all fit, Laura, into modern workplaces.
Thanks, Hilary. As many of us will have experienced and already know, many workplaces have changed over the years for a variety of reasons, including because of technological developments, evolving employee engagement initiatives, and industry developments. These changes not only impact how work is performed, but also often where work is performed. As workplaces and work practices develop, so too do areas for mental health risks, such as working from home, workload and changes within the workplace, difficult processes, managing ill and injured employees, as well as addressing complaints and workplace conflict. As with the recognised psychosocial hazards that Hilary discussed, none of these are truly new, but some have developed to look a bit different over time because of how workplaces have evolved, including in relation to the circumstances in which mental health risks can arise. As Hilary discussed, identifying risks and addressing them is crucial. Where there are jobs that have inherent or well-known risks, for example, these inherent or well-known risks must also be addressed and can't just be treated as just part of the job. An example of this is customer service jobs, or really any job that involves dealing with the public. How members of the public engage can be unpredictable, but where issues arise and risks are identified, they must still be addressed. In Skinner and Workers' Compensation Regulator, a decision from the Queensland Industrial Relations Commission, a local government employee successfully appealed the rejection of her workers' compensation claim after developing a psychiatric injury in the course of her work. The employee worked in a role that largely dealt with matters regarding impounded animals, noise complaints, and other animal-related complaints. In dealing with the public via telephone in her role, she was regularly exposed to aggression and abuse, including being called stupid or a bitch. She was also abused by a ratepayer while shopping after work because she was wearing her council uniform. Over time, the abusive interactions wore her down, and after 2.5 years in the role, she ceased working, having developed a psychiatric injury. The Commission did not accept that the injury arose out of reasonable management action in those circumstances. Rather, the Commissioner outlined that any management action that was taken to buffer the employee from the impacts of the negative interactions with the public was so minimal as to be ineffective. It was also found not to be reasonable due to the absence of formal reporting practices, as well as there being monitoring failures. Working from home is also an area where risks can arise. Working from home, or a mixture of working from home and working from the office, has very much become the norm for many businesses. How it could be implemented may differ from business to business. What needs to be kept in mind is that where employees are authorised to work from home, home can become the workplace, and duty of care and workplace health and safety obligations are still required to be complied with, including regarding mental health risks. In addition to the home containing physical hazards that need to be assessed, such as potential trip hazards, ergonomic considerations, such as making sure the workstation setup is appropriate, there are also psychosocial risks that need to be considered when assessing a work from home request, such as, are there domestic or family violence risks? Can the employee be appropriately supported and supervised while working remotely? And ensuring appropriate workload management and ensuring that any work stress issues are managed. In looking at whether to support a work from home request, it's also important to consider whether the role is appropriate to be done from home or another remote location. And by that, I mean not just whether the employee can meet the business's requirements working from home, but also what supervision and support the employee as an individual may need. For example, if someone is not performing to the level required by the employer and is being placed on a performance plan, a working from home arrangement may not be appropriate for that particular employee, as it will be more challenging to be able to properly supervise the employee, but also to provide support to actually give them a good opportunity to demonstrate improvement in their performance. If working from home is something that a business wants to support more generally for its workforce and not just on necessarily an ad hoc basis, a remote working policy may be a good idea, as it can clarify expectations as well as what is required from employees who may wish to work remotely, including what information is needed from the employee themselves. Whether you have a written policy or not, risk assessments are still important, including obtaining information on the proposed work area. This can be done by self-reporting by the employee in conjunction with a virtual tour of the proposed work area. It's also to be important to be clear on what is actually the workplace and be clear about things such as when the employee is to start and finish work and their work hours. It remains important that supervision is still appropriate and that employees are not forgotten on the assumption that they're working fine and they'll just reach out if they need anything. Providing proper supervision, including through video conferences and phone calls, not just emails, provides opportunity to identify if an employee needs more assistance or if something might be wrong. If there are concerns about an employee's work hours, for example, they're sending emails at odd hours, as a manager, there are options available, such as making sure you engage with HR, including to potentially engage with IT, to have a more broader review of the person's online engagement, including when they're logging on, logging off, to see if, for example, sending odd emails and working at odd hours has become a pattern that needs to be addressed. And also periodically assess whether the arrangement is working, in particular where circumstances change. A case from the Administrative Appeals Tribunal from a few months ago provides a good example about working from home and the need for good communication between a manager and an employee. In Peterson and Comcare in 2018, Mr. Peterson's workload increased significantly after 2 members of his team were suddenly absent. Mr. Peterson's team was already understaffed and he struggled with the additional workload, so was working additional hours from home as well as on his commute to the office. On top of this, his relationship with the acting manager was described in the decision as being fractured. The employer had an established practice that employees regularly working from home without the need for permission if an unexpected event occurred. In May 2018, Mr. Peterson sent his manager a text message saying he would be working from home that day because a tradie at his house had been delayed. The next day, when Mr. Peterson was at work, his manager didn't discuss the text message or him working from home with him. However, a few days later, she sent him an email outlining that under company policy, Mr. Peterson was required to seek prior permission for his absence. The email went further and also outlined that employees were carrying heroic workloads and Mr. Peterson would have to work hard to restore her trust and show the team he was reliable and respectful of their workloads. Mr. Peterson then developed a psychiatric injury and made a workers' compensation claim. In accepting the claim, the tribunal found the manager's actions in sending the email were not reasonable, in particular as the comment about Mr. Peterson requiring prior permission was not correct. The manager was not justified in using critical language. The manager, by not speaking with Mr. Peterson the next day about the matter when they were in the office, more likely than not led him to believe that there were no issues or concerns. The issue should have been addressed in a far less confrontational way, and the manager failed to take the opportunity to discuss the matter with him face-to-face. In saying the manager should have had a face-to-face meeting, the tribunal also said that the manager should have conducted the meeting in a way in which Mr. Peterson was given ample opportunity to explain his side of the story, and in a way that recognised that Mr. Peterson had been feeling depressed and down. The manager should also have consulted with HR for guidance before sending the email. In another decision that demonstrates the importance of being clear on what is the workplace and what is an employee's scope of work is the recent High Court decision of CCIG Investments and Shockman. Mr. Shockman worked on Daydream Island and was required to live in employer-supplied accommodation, which he shared with a colleague, a man by the name of Mr. Hewitt. Early one morning, Mr. Shockman awoke to Mr. Hewitt, who was intoxicated and was urinating on his face. Mr. Shockman had a pre-existing set of medical conditions, and as a result of Mr. Hewitt's actions, those conditions were exacerbated, but he also suffered on top of that post-traumatic stress disorder, which led to him being diagnosed with an adjustment disorder. He was ultimately assessed as having whole person impairment in the range of 10 to 20%. The issue for the employer in this matter was whether it was vicariously liable for Mr. Hewitt's actions. Mr. Hewitt and Mr. Shockman were not performing work at the time of the incident. The Queensland Court of Appeal found that the employer was, however, vicariously liable, with the requisite connection arising from the employer requiring Mr. Hewitt to live in the shared accommodation and the terms of his employment, which required him to take reasonable care that his acts did not adversely affect the health and safety of other persons. The High Court took a different view and allowed the employer's appeal and confirmed that in Australia, for an employer to be vicariously liable for the wrongful conduct of an employee, the employee's wrongful act must be done in the course of or scope of the employee's employment, and what the scope of an employee's employment is depends on the circumstances of the case. The High Court outlined that while an employer's express authorisation is not needed for an action to be within the scope of employment, a greater connection is needed than the employment providing only an opportunity for the conduct to take place. In this case, the High Court found that what Mr. Hewitt did had nothing to do with what he was employed to do. and at most, the shared accommodation only created a physical proximity between the two men and provided Mr. Hewitt the opportunity for his actions to impact Mr. Shockman. While the employer was successful in this case, what the decision does highlight is that employers must therefore take a considered approach to their duty of care, as it can extend beyond what is considered the traditional workplace, especially where circumstances arise such as the employer provides accommodation, requires employees to travel for work, or provides activities outside of ordinary work hours and requires or encourages employees to attend. For more information about this case and the impact on employers, Hilary and I have written an article for Clayton Ut's Insights on this case, and that can be found on Clayton Ut's website. While days like Are You OK Day provide a good opportunity to promote awareness of mental health matters and looking at initiatives, including educating and encouraging people to be involved, creating and supporting a mentally healthy workplace requires a multifaceted approach. There are a range of things that employers can do to support a mentally healthy workplace through everyday steps and interactions. In looking at practical tips more broadly, we've already discussed looking at your health and safety obligations, considering the physical workplace, including for employees who work remotely, and identifying and addressing risks specific to your industry or business. In unpacking this further, also make sure your policies and procedures are clear and ensure employees know about them and that they are followed if they are breached. It's also important to support managers to develop their skills, to feel empowered to deal with issues in accordance with your policies and procedures. Make sure complaints and concerns are addressed, even if there isn't a formal complaint. Many complaints often create an opportunity to do something, even if the complaint itself is not ultimately substantiated. For example, did the events or situation that gave rise to the complaint occur and provide an opportunity to reinforce workplace expectations to your staff, provide further education, or even maybe things more specific such as, is there a need to provide clarification regarding work roles? Be alert to inappropriate workplace behaviour, and even if you yourself don't see it, if someone raises a complaint, it is crucial that it is dealt with, as failing to do so can result in claims. For example, in RAD and Fresh Food Management Services, which is a New South Wales decision, an employee of 38 years ceased work due to anxiety and stress caused by a co-worker. The co-worker bullied the employee for 5 years, including by shouting at him and by undermining his authority as a team leader. The behaviour, however, only occurred when management was not on site. The employee complained to his employer about the behaviour, but despite the employer facilitating meetings, the complaints were not resolved and the issues continued. The straw that broke the camel's back appears to be the co-worker was then promoted and became the employee's supervisor and allegedly told other staff he was going to go after the employee. This caused the employee to cease work and be diagnosed with a psychiatric injury. The employee made a workers' compensation claim and the employer sought to defend it, including, amongst other things, by saying that the injury arose from reasonable action taken by the employer, including in relation to promoting the co-worker. The employee, however, was successful, with the member looking at the circumstances holistically and finding that the impact of the promotion actually had a special context after years of poor interaction between the men. And looking at other tips, be clear and consistent in communications. Making unclear or inconsistent requests or directions can be a source of stress for employees, especially if the request is in an email and the recipient doesn't have an opportunity to discuss the request with the person making the request, especially if there is a time pressure attached. Supporting processes and communications with a paper trail is very important. It can be both beneficial for managers and employees, especially when there are challenging processes on foot. Not only does it evidence your reasonable management action, but can also be a support to employees who at the meeting might be stressed, might not actually be properly taking everything in. And so having a letter setting out what is discussed and what are the next steps, for example, can be something the employee can consider after the meeting finishes when they are feeling calmer and in a better state of mind. Prepare and plan for challenging discussions. This includes brainstorming what reactions or questions you might get so that you can be ready. If you don't have as much experience with dealing with meetings where an employee gets very upset or angry or seeks to derail the discussion, it can be quite confronting when it occurs. And so planning beforehand and being ready for such interaction can be very helpful. Also be alert to sensitivities, taking into account what you know about the employee, including if there are personal matters you are aware of, can be important. Now, this doesn't necessarily mean that you have to have a different process or abandon a process, but what it means is that you've considered, based on what you know, whether what you're about to do is the most reasonable approach in the circumstances. If you have concerns about someone, including in relation to their behaviour or concerns about their health, for example, talk to them. Don't make assumptions. Making assumptions, such as attributing the cause of a problem to something speculative, such as assuming someone's work performance decline is impacted due to illness, is often unhelpful in trying to resolve the problem, but can also result in you undertaking the wrong process. It may also be a breach of legislation, including anti-discrimination legislation. If there are concerns about fitness for work or medical disclosures that have been made, and you don't have enough information to understand the situation, there are steps you can take to obtain more information, and I'll touch on that shortly. And a constant theme that seems to be popping up more and more in case law is involve your HR and safety teams early. They are there to provide advice and support, and I'm sure they would all welcome being involved early rather than only being brought in once the claim is made.
And sorry to interrupt, Laura, but one of the questions that come up is whether some of the sexual harassment and the psychosocial hazards is a WHS issue or an HR issue, and who should be undertaking the risk assessments. And I think to that, your point that you're making there, we often see that sometimes health and safety teams and HR teams are really disconnected in their workplace. They're not necessarily talking to each other or understanding what each other are doing. But I think this is a space where really all of those teams need to be working together, and it should be something that's done in conjunction between HR and WHS teams, because the psychosocial hazards, sexual harassment, managing ill and injured employees, it creates an impact for the whole organisation and often needs a whole of organisational approach.
Exactly. And going on from that, initiatives are not a substitute for doing proper risk management. For example, having a comprehensive employee assistance program is a good thing, but if there are known issues such as workload issues or bullying within the workplace, and these issues are not addressed by the employer, a business will not be meeting its legal obligations, but will also not be a place where people actually want to work at or do their best. When looking at implementing initiatives, consider culture, risk management, and initiatives holistically. If you are rolling out initiatives, consider the impact on employees and incorporate this into your messaging and implementation. This includes even for more positive and less formal initiatives that is designed to be more fun. Late last year, the media was reporting on a French case where a man was sacked for being insufficient professionally because he didn't get involved in team building activities with colleagues. The team building activities, from what I can gather from the media reports, look to be just drinking excessively after hours and on weekends. But as a result of the heavy drinking, it created an environment where employees were encouraging each other to behave promiscuously and in a bullying way. The former employee was successful before the industrial court, who awarded him around 5,000 Australian dollars, finding that the company couldn't make him forcibly participate in meetups and weekend drinks that frequently ended up in excessive alcohol intake and harassment by colleagues, and the former employee had a fundamental right to dignity and respect for his private life. Now, while that's a French case, and obviously doesn't apply to Australia, there are still takeaway messages in terms of, I'm sure that team probably thought they were all having a great time and it was a good team building initiative, but what might be enjoyable for one person might be completely unenjoyable for somebody else and actually create its own risks.
I was going to make a joke about karaoke, but I won't.
For the record, I am not a fan of karaoke. That is because I am not talented. And so I mentioned employee assistance programs earlier. Employee assistance programs are becoming more and more common as a support initiative offered to employees as part of that, package for looking at ways to support wellbeing in the workplace. There are many different EAP services available with different offerings, not just counselling. If EAP is something that your business offers, ensure employees and managers are aware of the service, including what it actually offers, as well as make it accessible. Employees are less likely to want to access EAP if, for example, the only way they can access it is by approaching their manager to ask for access and the manager arranges for access. It's also important that if you have services in place, to get feedback on whether they're being used and what feedback is being provided by the users. This can be done by asking for that information from the provider themselves and doesn't involve identifying employees, but can be a good way to look at whether what you're offering is appropriate for your employees or whether it should be modified or even expanded. The importance of ensuring EAP is appropriately accessible is highlighted in the recent decision of Paul and State of New South Wales, where a worker was awarded over $1.8 million in damages after sustaining a psychiatric injury. The employee was a police officer who'd been working on the Royal Commission into Institutional Responses to Child Sexual Abuse. When he asked for his team to be included in the New South Wales Police's WellCheck program for workers at higher risk of psychological harm, his superiors approved it. The program was an extension of the employer's EAP and incorporated a range of services such as psychometric testing, job rotations, quarterly interviews, interim well checks as required, annual psychological tests and self-care plans. So a very comprehensive package. However, it turns out the team didn't actually qualify for the program. So the EAP provider didn't provide it to the team, which his superiors weren't aware of and the officer wasn't made aware of. The services the team could access instead were completely different and much less comprehensive, being ad hoc counselling on 3 or 4 occasions. As the services were bound up in a series of decisions the employer made on what assistance would be offered through its agents, the judge found that the employer was vicariously liable for the services falling short of what was requested. Also, as set out in the slide, the judge also made the comment that mere provision of a counselling or other psychiatric intervention service to be availed of does not discharge an employer from its duty of care to take reasonable steps to ensure a safe system of work is in place. From time to time, employees may be ill or injured, whether work-related or non-work-related. Situation, it can give rise to a range of questions as seen on the slide. Understanding your obligations and options as an employer can help support employees with their return to work, or unfortunately, if an employee is ultimately unable to undertake the inherent requirements of their role, ensuring a legally defensive dismissal process. When dealing with ill or injured employees, it's important to be aware of the legislative framework that applies, and I've included a summary of key points in legislation on the slide. I note that because Hilary and I are based in Queensland, it has a largely Queensland focus. However, regardless of the state or territory that you are in, it's important to be aware of, in addition to the Fair Work Act having obligations, there's also obligations under anti-discrimination legislation in relation to disability discrimination, but also if an injury or illness is work-related, there are also protections and obligations under workers' compensation legislation, including, for example, prohibitions on terminating an employee as a result of incapacity arising from their compensable injury for a certain period of time. So what this means is, regardless of where your business is based in Australia, there are steps that can be taken to help support ill or injured employees. Where appropriate, it's important to engage with employees who are away due to illness and injury, including for a welfare check. What I mean by where appropriate is that it depends on each employee and the situation. So, for example, if an employee has a medical certificate that makes it very clear that they cannot be having any contact from their employer, I wouldn't be doing a welfare check in that situation. And like with the tips discussed earlier, make sure to document interactions and decisions, especially where you're asking an employee to do something such as provide information, you're making adjustments to their work, or you're putting in place a return to work plan. Ultimately, the goal for someone returning to work from illness or injury is to be able to undertake the inherent requirements of their role. Being able to undertake inherent requirements means to be able to safely perform the tasks or functions which are a necessary part of the job. This includes meeting productivity and performance requirements, be able to work within the circumstances required by the job. So, for example, is it a role that requires someone to perform night shifts or a requirement to perform their role on site? And be able to work within their team and be supervised. In supporting someone reach that goal, adjustments may be needed, and what adjustments may be reasonable will depend on the information you have, including from the employee and the doctor. It's important, again, that you do not make assumptions. If you do need information to be able to understand an employee's fitness for work, a starting point is what does their employment contract or relevant enterprise agreement or your policy or procedure provide in terms of a process? Ultimately, the employee's consent is needed, though, to obtain information, and whatever information is received must be treated confidentially. When considering where to start in obtaining information, consider what you may already have in terms of what certificates have been provided and what the employee has told you. Where you have very limited information or inconsistent or unclear information, often a good place to start in terms of getting more information is the employee's doctor, as they hold the employee's medical history. If that information is not sufficient to understand an employee's fitness for work, including, for example, specialist information is needed and the employee doesn't actually have a treating specialist, independent medical examinations are also an option. And what information you may have previously obtained relevant to the specific issue can form part of the briefing to the IME doctor. When going down the IME pathway, it's important that the doctor is from an appropriate specialty. While it appears obvious that if an employee's incapacity relates to a mental health issue or psychiatric injury, a psychiatrist is the appropriate specialist to schedule the IME with. However, sometimes employees can have more complex medical situations, including they might have multiple medical conditions that might be impacting their ability to perform their roles safely. And so sometimes more than one IME doctor may be needed. Or potentially an occupational physician is the better specialty. When briefing the IME doctor or doctors, or even when seeking information from the employee's own doctor, ensure that the briefing is appropriate, including what questions you want answered. It's also important that it's clear what the job requirements are and what the work environment is as well, as you'd be surprised how many doctors have a completely different idea about what their patient does or the person they're assessing does versus what the employer says that the role is. If you don't provide a sufficient briefing, unfortunately what it means is the IME doctor or the employee's own doctor will base it on largely what they're actually being told by the person. If the report you obtain from the employee's doctor or from the IME does not address what you are asking, or it contains inconsistencies or it's just unclear, seek clarification from the author. This includes that if an opinion in the report appears to be based on incorrect information or a misunderstanding by the doctor, and a classic one being the doctor has a different idea of what the employee does versus what the employee's actual role is. And to wrap up, I'd like to point out that there are a lot of support services in the community. Even if your business does not have an EAP service that it offers to employees, there are a range of options for support available, including that specialise in different areas, such as in relation to domestic violence, whether you may need support for yourself at any point in time or someone you care about or a colleague or even somebody that you supervise. It's good to be aware of what support services are out there, and we've included some details on the slide of some services such as Lifeline, Beyond Blue and Headspace. While today's seminar really is a high-level snapshot of some issues and developments in this space regarding workplaces, we hope that today's session helps equip you to be alert to and identify issues and be well positioned to be part of creating and supporting a mentally healthy workplace.
Thanks, Laura. We've had quite a lot of questions come in, so we might go through those. I'll try and make sure we address main questions that have come through. One of the things that people have been asking throughout the presentation is just names of cases and things like that. We are going to circulate the slides after this presentation, and the details are on the slides, and hopefully that will assist everybody. Whoops, hang on. We won't go back to the beginning and just make sure we can address that. So somebody's asked a question, would the risk assessment on sexual harassment be a compliance requirement from the 12th of December, obviously when the Human Rights Commission is going to have those additional powers. Now, I'd be suggesting that we take those steps now to make sure that you're doing those risk assessments and looking at your business and looking at your activities now. It is going to be useful evidence, I think, from the 12th of December around compliance, but obviously that duty is now in place, and you already have the psychosocial hazards compliance requirements in a number of states and territories. So I'd be suggesting that whilst that would be useful from December onwards, I think it would be very useful right now, and I'd be taking those steps to start looking at that from now. We've talked about, I think they're not somebody asked as well whether the psychosocial hazards legislation is applicable across all jurisdictions. As I mentioned earlier, it's not yet in all the states and territories. Some of the states and territories have not yet put it in place, but I think it will be coming. In most of the states and territories where it's not yet in place, for example, Victoria, there is draft legislation that's already been considered and is out there for feedback. So, and again, if it's not already in place in your state and territory, I'd highly recommend that you become aware of what is being put in place in the other states and territories, and make sure that you're across the codes of practice and the information. Thanks, Laura. Laura's way better at technology than I am. It states it so that because this is information that you're going to probably know or reasonably know. We might just go up, see if there's some other questions on the other aspects. Somebody asked a question around EAP, Laura, and in terms of how do we sort of expand or check our resources. I think a lot of people are always surprised by how many resources and offerings EAP provides. So I think as a first step, I'd recommend that you contact your EAP providers and get a really full understanding of what your package entails. Another participant noted that really EAP has changed so much over the last few years. It used to be this throwaway sort of line people write in letters, but now it really is a much more expanded offering, and I think becoming aware of what is available and checking your packages. And if you want to be able to offer more to your organisation, I think that's something need to explore with your EAP provider. Laura, did you want to add anything to that?
No, I think that covers it. And one of the questions, unsurprisingly, a lot of working from home questions have popped up as well, with
Yes.
one of them being, what's the obligation of employers to provide equipment to employees who work from home voluntarily? In terms of providing equipment, it really depends on case-by-case basis, but ultimately what the obligation is the employee, if they're working remotely, has to be safe in doing so. If the work environment at home is not safe because, for example, the employee doesn't have a proper chair, they're sitting on the ground hunched over doing work, that can be a basis to say, look, I'm concerned that you actually don't have a proper work setup to be able to work safely. That doesn't mean you have to say, I'm going to buy you a whole new home office. It just means, it's what you as an organisation are prepared to do to provide support to facilitate working from home safely, or whether it becomes a decision to say, sorry, we need to see more from you, employee, before we can assess whether this is actually a safe course.
And somebody else asked a question about whether working from home, if somebody becomes injured, is that where the sort of liability sits? Again, if you are working and allowing your staff to work from home, that becomes a workplace, and all of the same obligations from a health and safety perspective, your duty of care to your employees will remain. So effectively the home becomes the workplace, and so you need to ensure that the home is safe so far as reasonably practicable. And if someone was to become injured, There's the tips and traps that we've been putting up in the recommendations there are designed around trying to make sure that you can set those limits and those parameters to say, well, no, actually, that part of their role that actually ceased work, we had put parameters in place to say, well, you're expected to work around these hours from here to here, and so that occurred outside of working hours. It was in your usual, you felt doing the dishes in the kitchen, but that was, outside of working hours. It's not related to the scope of work, and set that aside. So it's really important when you're considering allowing staff to work from home that you have those parameters and that you've considered how you're going to manage those types of issues, including investigating how are we going to investigate an incident that occurs at home.
And one of the questions that's come up is if we're unclear about a medical condition that's listed on a medical certificate, do we need consent from the employee to contact the GP? Short answer is yes, including as the GP just won't talk to you if they don't have the consent from their patient to do so. Often if an employee is not prepared to provide that consent, that can be quite difficult to manage. And so you'll need to look at, again, what's under your policies and procedures, the employee's contract, any relevant enterprise agreement, but also consider, whether you can issue a lawful and reasonable direction in relation to providing information, because at the end of the day, as an employer, you need to be satisfied that the employee is safe and able to perform the inherent requirements of the role. And if you don't have sufficient information, that's obviously going to hinder that process. Scrolling down, there's a lot of questions. We might not get to everybody, but in terms of a question that's come up in terms of what kind of questions can be raised with the IME doctor, ultimately the questions need to be relevant and tied to the concerns regarding the employee's ability to perform the inherent requirements of the role. You can't just ask any old question. It needs to be very much focused on these are the concerns that we have in terms of, for example, an employee's been consistently absent, but has been saying it's because, they're stressed or, they've got these conditions, or they can't perform, for example, night shifts because of medication that they are taking, but you don't have enough information to understand what that looks like, including is this a temporary thing versus do we need to look at long-term whether they can actually perform their role. And so in terms of the questions that can be raised, you look at what you've got and then you look at what you need. And so if, for example, you don't have any clarity about a diagnosis, you ask that. If you don't know what that means in terms of, what symptoms is the employee experiencing, what medication they are on, and ultimately what you want to ask is, how does this impact, if there is any impact, upon the employee's ability to perform the inherent requirements of the role? And in your briefing, you set out what those inherent requirements are so that the doctor can consider it and make an assessment as to whether the employee's medical condition actually does have any sort of impact.
And often the type of reports you're going to get back from your IME are so dependent on the nature of the questions that you ask and your briefing of that doctor. So really that is a really critical part of the process, and we can't overemphasize how important it is to get that right. And to seek those clarifications if the answers and the responses that you're getting back don't answer the questions that you need them to.
Exactly. And and one last question, I think been asked, can a poorly designed or implemented performance assessment process be a psychosocial hazard? And if yes, any suggestions for managing the risks if someone is unhappy with the process? Yes, a poorly designed any process in the workplace can be a psychosocial hazard. Just because an employee, however, is unhappy with the process doesn't mean it was poorly designed. And what you will be assessed on in terms of, especially if, for example, a workers' compensation claim is made, is whether the steps you've taken are reasonable in the circumstances. But some common things that arise in terms of how processes can be better go back to some of the tips we were discussing in terms of, for example, making sure you have, you are following a policy or procedure if you have one, making sure that you're documenting what you're doing and you're documenting what you're communicating with the employee, but also depending on what you know about the employee, making sure that's taking it into account. But also, I think recognising that processes such as disciplinary processes and performance processes, even if you're super justified in implementing them for that particular employee, recognising that they are going to be stressful for the employee, and making sure that there is appropriate support, including, for example, if it's a disciplinary process, is it an appropriate step to say, look, to support you, well, we need you to respond to a show cause letter, we're going to place you on paid leave without deduction to your leave balances. Of course, if you've got EAP available, reminding the employee that that is available, making sure even just little things like being clear that if the employee has questions, including in relation to, the disciplinary process or performance process, who is the best contact for the employee to ask questions? Sometimes frustration arises from an employee not actually knowing who they can actually ask questions from. So there are a range of ways that, processes can be, reasonable or, best placed in terms of defensibility, but also supporting an employee through that process.
And I'd just add to that, Laura, when you're having to manage employees, you're having to manage poor performance or conduct issues, none of those conversations are easy. They're not easy on the managers and they're not easy on the person who's receiving those, but it's really critical for the organisation and for everyone as a whole that those conversations occur and that the issues are managed, and that the preparation is key, we would say. Prepare yourself for those difficult conversations, work out how you're going to address it, work out how you're going to deal with the staff member, for example, after that difficult conversation. How are you going to get them home? Offering of that support person present perhaps, or EAP, or even counselling on site. So thinking about all of those things in advance will really help place you in the best possible position to have those conversations and to make sure that you're not ending up with claims as a result of those to the extent possible. And we might leave it there given the time, but thank you everybody for all the questions, and thank you for attending, and we look forward to having a great Are You OK Day this year. Thank you.